Hi, everyone. Welcome to today's training, Supporting Tribal Families under Cal-ICWA, Legal Advocacy for Kinship Placement. My name is Suzanne Garcia, and I'm a Tribal Legal Specialist with the Tribal Law and Policy Institute. Today's training is designed specifically for attorneys who represent tribes in dependency proceedings. Our focus is on practical legal advocacy, how to use tribal laws, California's Cal-ICWA, and federal ICWA to work with your client to advocate for placement with family and to advocate for compliance with ICWA as directed by your client. Next slide, please. This presentation has a companion set of materials in Google Classroom. There is a pre- and post-test and a progressive case study. Please use the QR code on this slide to open the Google Classroom assignments for this module. Once you're in the classroom, please select Classwork. There you'll see the pre- and post-test, a progressive case study, and in a bit we'll be pausing this presentation so you can take the pre-test. As for the progressive case study, we encourage you to use those materials to apply what you've learned today after you view this presentation, and maybe walk through them with your colleagues. Also in the classroom, there's a list of resources and links to some of the documents we'll be referring to during this presentation. Let's continue by looking at what you'll actually take away from this webinar. By the end of this session, you'll be able to distinguish between federal ICWA and California's ICWA when Cal-ICWA provides more protections. You'll be able to formulate legal arguments to overcome common barriers to placement with family. You'll be able to describe the link between the effects of historic and ongoing trauma and modern client distrust of child welfare systems and apply this to educating the courts and others. Because understanding why families may distrust the system is essential to effective advocacy. You can't represent a tribe well if you don't understand this context. Finally, you'll be able to identify how Tribal Customary Adoption, or TCA, as applied in California, can be used as a permanency option tool that avoids termination of parental rights. But first, let's frame your role. Next slide, please. This slide is your roadmap for the entire training. Each numbered item corresponds to a practice tip that we'll cover. Your client is the tribe, and your job is to advocate for their families as directed by them. The California Tribal Families Coalition's publication, Performance Standards for Attorneys Who Represent Tribal Governments in State ICWA Proceedings, has a great section that will help you determine who at the tribe you should work with to get that direction. So we're not going to go into it here today. But overall, your role is to advocate for Native families as they direct. To do that, as their attorney, you should know the tribe's definition of extended family, know and advocate for the tribe's placement preferences, anticipate challenges, because the other side might argue that there's good cause to deviate from those placement preferences, ensure that placements are considered in accordance with the tribe's prevailing social and cultural standards. This will be a powerful tool in advocating for Native families. Understand the approval process for placements. Know tribally approved home and resource family approval processes and the role that tribally specified homes play in placement decisions. You should also advocate with awareness. Families may carry generational trauma, and their actions can be misunderstood or mischaracterized. As the tribe's attorney, you should advocate for them throughout the case, which can be an extremely stressful and invasive process. You should also understand tribal customary adoption, know how your client does it, and advocate for it at their direction. And finally, you should advocate for services and supports after the case closes. The needs of these families don't end at permanency. Families need ongoing support so there isn't a disruption and they don't re-enter the child welfare system. We're going to take each of these in turn, but first let's see where you're starting from. Please get ready for the quick pre-test. Please go to the pre-test in Google Classroom. Take about 10 minutes to complete it. It's not graded, it's for your benefit as a knowledge check. Don't worry if you're unsure on some of these. That's exactly why we're here. You'll do the same test at the end of the session and you can compare. All right, let's dive into our first topic, how extended families are defined. Next slide, please. This is our first and perhaps most foundational practice tip. Before you can effectively advocate for tribal families, you need to understand how the tribe you represent defines extended family. I want you to think for a moment. For the tribes you've worked with, how do they think about extended family? And if you haven't worked with the tribe yet, think about your own family. Who counts as family? As you do this work, what you'll likely find is that tribal definitions of family are much broader than how families were traditionally defined in state and federal dependency systems. Those definitions are legally significant because they directly affect placement preferences. So next, we're going to look at how the different legal systems define extended family. Often, tribal laws recognize relationships by tradition, custom, and consensus. The term extended family often includes people who don't have a blood or legal tie, but are considered family by the community. California and federal law acknowledge those who are recognized by the law and custom of the tribe, and in the absence of that, will fall back to those related by blood or marriage. So the practice point is that as your role to know your client's definition. If the tribe doesn't have this defined, support the development of something so you're prepared for individual cases. Develop a relationship with social services and in-house counsel if you can, and find out how your client would like to go about establishing this definition. Next, we're going to look at some examples of how tribes have defined extended family in their code. So we're going to look at 3 California tribes and how they define extended family. The Yurok tribe includes a standard list: grandparents, aunts, uncles, siblings, in-laws, and cousins, but then adds, or is recognized by traditional village custom and/or practice as an extended family member. That last clause is critical. It allows for anyone the village recognizes as family. The Washoe tribe takes a different approach. Extended family is defined entirely according to tribal customs and traditions. No list at all. It's entirely self-determined. The code of the Pit River tribe says that any person related by blood or marriage, or any person recognized by the law or custom of the tribe. Again, custom is a key word. So notice the pattern here. Every one of these tribal definitions includes a custom or tradition-based catch-all. This is intentional. Tribes understand that family doesn't always fit into predetermined categories. So next we're going to compare federal and California statutory definitions. Just a quick note, we're including federal laws in this presentation so that you're prepared should you represent a tribe from outside of California. They might have different understandings of ICWA and how it applies, and part of your job will be to explain the distinction between federal and California law. So under federal law, 25 U.S.C. 1903, Section 2, the tribe's own definition of extended family member takes priority. The federal statute only provides a default list, grandparent, aunt, uncle, sibling, etc., based on blood ties, which applies only if the tribe hasn't defined it themselves. In this instant, California law at the Welfare and Institutions Code, Section 224.1, Section C, parallels federal law. But this is important. The federal and state definitions are a fallback. If the tribe has their own definition, that's what should be used. Now that we understand who qualifies as extended family, let's talk about why it matters. Placement preferences. But first, another quick note. Because today's presentation is focused on advocating for Native families, we're only going to discuss the order of placement preferences. When dependency systems are considering which placement is best for children, there are additional dependency considerations which are beyond the scope of this presentation. For example, placements must be in the least restrictive setting appropriate to the child's particular needs. As you do this work, you'll have to apply those considerations, but again, they're beyond the scope of this presentation, so we won't be going into them here. The next practice tip is to know placement preferences as established by tribal, state, and federal systems. The definition of extended family is critical because it directly drives who gets priority in the placement preferences. Under both federal ICWA and Cal-ICWA, and for many tribes, a member of the child's extended family is at the top of the placement preference list. So if you have successfully established that someone is an extended family member under tribal law, you've just moved that person to the front of the line for placement. This is why tip number 1 and tip number 2 are so closely connected. So let's look at the specific statutory language that lays out those placement preferences. We're going to look at placement preferences from 3 angles: California law, federal law, and tribal law. You need to know all 3 because they interact, and in some cases they diverge. On the California side, we're going to be spending a lot of time looking at Welfare and Institutions Code 361.31. This is Welfare and Institutions Code 361.31D. And when it comes to serving tribal families, it's one of the most important provisions in Cal-ICWA. So read this language carefully. If a different order of placement preference is established by the child's Indian tribe, the court shall give full faith and credit to the preference established by the tribe. So 2 things to highlight here. First, the tribe establishes its placement preferences. The statute doesn't limit how. It doesn't say by resolution, which, as we'll see, the federal statute does. It could be done by tribal code, a resolution, a letter from tribal council, or an established custom as testified by a subject matter expert. Know how your tribe, how your client has established their preferences, and educate the court and others involved in the case. Second, full faith and credit. California deliberately used this constitutional language. The legislature is telling the courts to treat tribal placement preferences with the same respect they'd give to laws of another state. This is powerful language. Now let's compare this with the federal version. This is 25 U.S.C. section 1915C. Notice the key difference from California. The federal statute says that if an Indian child's tribe shall establish a different order of preference by resolution. Federal law specifies the mechanism. It has to be a tribal resolution. California removed that limitation. If you are representing a tribe from outside of California, they might be unaware of this distinction, so it might be important to discuss that with them. Under Cal-ICWA, you have more flexibility. If your client doesn't have established placement preferences, in a best case scenario, that's a conversation that you will have with your client prior to a case, not when you're in the middle of a case. However, if you are in the middle of a case, the fact that you aren't locked into needing a resolution, which can be time-consuming to obtain, gives flexibility that's in your favor. Now we're going to look at the actual placement preferences themselves. First, we'll look at how one tribe has codified those placement preferences. Next slide, please. As you look at this example from Koduk, note how detailed it is. There's 9 tiers, starting with immediate family, then extended family, then other tribal members, then other Indian families, then various level of approved homes. The next slide will talk about the federal foster care placement preferences. 25 U.S.C. Section 1915B sets out the federal foster care placement preferences. The preference order is extended family, a foster home licensed or approved or specified by the tribe, an Indian foster home licensed by any authority, an institution approved by a tribe or run by an Indian organization. Remember, extended family here means the tribe's definition of extended family. California's version adds some important enhancements, so let's look at their placement preferences. Welfare and Institutions Code, Section 361.31b mirrors the federal preferences, but with key additions. First, California explicitly extends these preferences to guardianship placements. Federal law doesn't mention guardianship. Second, California specifies that these preferences apply in emergency removals of children who are known to be Indian children or when there is reason to believe to know, and when there is reason to know they are Indian children. This is significant. The preference order is the same. Extended family, tribally licensed foster home, Indian foster home licensed by a non-Indian authority, institution approved by tribe or run by an Indian organization. Again, the tribe's own placement preferences override this order of preferences under Subdivision D with full faith and credit. Next, we're going to look at adoptive placement preferences. Federal and California law use similar language. Please note that these adoption preferences apply anytime adoption is the permanency plan. This includes voluntary adoptions and adoptions following termination of parental rights in dependency cases. The adoption preference order is extended family, other tribal members, and other Indian families. Please note the language. Next slide, please. Please note the language in the foster care placement preferences in the absence of good cause to the contrary. This phrase can do Native families a lot of harm. What happens when someone argues that the court should deviate from these preferences? That's our next section. Good cause arguments that you as the tribe's attorney should be anticipating. This is an area where cases can get heavily contested. You've established that your client's placement preference is an extended family member, but the county, ICWA, or even the child's attorney may argue that there's good cause to deviate from those preferences. Your job is to anticipate those arguments before they're made. Think about what the other side will say and prepare your response. Let's look at what the statute actually says about this area of law, and I'm going to concentrate on California law in this section. Two critical procedural points here. First, under Subdivision H, if someone claims good cause exists, they must state the reason on the record or in writing. No vague, unsubstantiated assertions. They have to be specific. Second, under Subdivision I, the party seeking to depart from placement preferences bears the burden of proof by clear and convincing evidence, which we know is a high standard. This matters for your advocacy. If the county or a federal or a foster family wants to argue good cause, make them carry that burden. Don't let the burden shift to the tribe to prove why the preferences should be followed. The preferences are the default. For those of you representing tribes from out of state, please note that the federal ICWA is not explicit about the burden of proof, but the regulations at 25 CFR 23.132 are explicit about the need for clear and convincing evidence. So what can actually constitute good cause to deviate from the placement preferences? We'll look at those on the next slide. The Welfare and Institutions Code, section 361.31J, gives a list of what can be considered good cause. We'll walk through each one. So one or both parents can request a deviation, but only if they attest that they've reviewed the placement options that comply with the placement preference order. They can't just say, I want my child here. They have to show that they know what the alternatives are. The child, if it's of sufficient age and capacity, can also request a deviation from the placement preferences. This is going to be inherently case specific. Sibling attachment is also a reason to deviate from the placement preferences, but only if that attachment can only be maintained through a particular placement. If siblings can maintain their relationship through visitation and other means, it's possible that this factor doesn't justify departure from the order of preference. 4 is extraordinary physical, mental, or emotional needs, and the fact that specialized treatment services are unavailable where preferred families do live. Note the word extraordinary. Routine medical or educational needs won't qualify as justification. The unavailability of a suitable placement is also a reason to depart from the placement preferences, but only after a diligent, timely, and thorough search. And here's the critical part. The standard for determining whether a placement is unavailable shall conform to the prevailing social and cultural standards of the Indian community. The county can't use its own standard to declare that a placement is, quote, unavailable. It must use the tribe standards. This fifth factor is where prevailing social and cultural standards do substantial work, and we'll come back to that in a bit. Equally, or perhaps more important, California has qualified what is not good cause to depart from the placement preferences. The exclusions listed here are explicit and non-negotiable. Subdivision K says that a placement shall not depart from preferences based on the socioeconomic status of any placement relative to another placement. Period. It doesn't matter if another placement has a bigger house, more money, or lives in a better school district. Socioeconomic comparisons are off the table. Subdivision L addresses bonding and states that a placement shall not depart from preferences based solely on the ordinary bonding or attachment that flowed from time spent in a non-preferred placement that was made in violation of ICWA. This is significant. If the county placed a child with a non-Indian family in violation of ICWA's placement preferences, they can't then in turn argue that the child has bonded with that family as the sole reason to keep the child there. Note the word solely. Arguably, bonding can be one factor considered alongside other good cause factors, but it can't be the only basis for departure, especially when the bonding resulted from an improper placement. Subdivision M is an important record-keeping requirement. The state must maintain records of placement efforts in perpetuity and make them available to the tribe within 14 days. If the county can't show that they took active efforts to identify a preferred placement, that undermines any good cause argument. Okay, next we're going to move on to examining how families are approved as placements. There are two pathways to get a family approved as a placement for an Indian child. In addition, there's a way for a tribe to indicate which placement it prefers. Tribally approved homes, or TAH, this is the tribe's own process. The tribe approves the home according to its own standards. Resource Family Approval, or RFA, so this is the county process. If the tribe is an approving home, prospective families go through the county's RFA process. And then we have tribally specified homes, TSH. This is the home the tribe designates as the preferred placement. It's not an approval process so much as it is a process for the tribe to indicate to the court which home it prefers. These homes can be tribally approved, they can be approved as a resource family, or they can be a home that's still pending one of those processes. Understanding these pathways matter because the approval process can be where tribal families hoping to care for a relative can get stuck. Families can get discouraged by the bureaucracy, or it could be that the county applies standards that don't align with tribal norms. So let's look at each of these pathways in more detail. Tribally approved homes is the tribe's own home approval process. When the tribe exercises its right to approve homes, it applies its own standards, not the county's. A key advantage is the fact that the tribe controls the process and the standards. If the tribe determines that a multi-generational home with shared bedrooms is appropriate, that's the standard. Naturally, standards vary by tribes. Some have detailed procedures, and others in the middle of developing that process. So if your tribe has their own process, it's recommended to use it because it gives the tribe the most control over placement decisions and can provide the most protection to the family. Under this process, background checks can be completed by the tribe. And also, it's important to note that tribes can approve homes before a specific child needs placement. They can have their own diligent recruitment plans and approved homes ready to go. In emergency situations, there's an expedited process that a tribe can use to ensure a child can be safely placed with a relative. Finally, and importantly, the training that these families must have in order to be approved is up to the tribe. In the next slide, we'll look at the resource family approval process. So this is the county's process. This slide represents all of the things proposed families must undergo to be approved. The RFA process involves background checks, home environment assessment, permanency assessment, training, and ongoing monitoring. And this is where many relative placements hit barriers. Sometimes there's issue with completing a background check. No one wants to be known by the mistakes they made in their past. Having a background check done can be intimidating and embarrassing. It's also possible that home standards won't account for cultural norms. Training requirements in classes aren't always culturally appropriate, and that can cause a barrier for a native family that's trying to get approved. And this process is just invasive and can be intimidating, much less for those who have a historic distrust of the government. Even when a county goes through an RFA process for an Indian child, it's important to remember that Welfare Code and Institutions Code 16519.5C3 requires that the county apply the prevailing social and cultural standards of the Indian community. Again, we'll cover this in more detail shortly. If your client has decided upon a specific family as a placement, as we mentioned a little bit earlier, there's the tribally specified home process. So this is where a tribe designates a home as the preferred placement. It's the tribe saying, we want this child placed here. It can overlap with the other pathways because the home can already be approved as a tribally approved home. It can be a home that has resource family approval. It can also be a home that is pending either process. So this last point is key. A tribe can specify a home even before it's fully approved. This can get the child placed more quickly while formal approval processes are still underway. This is an important tool for tribal attorneys. If your client has identified a placement, ask them to designate it as a TSH. This puts the tribe's authority behind the placement and triggers the preference provisions. Now let's talk about the legal standards that tie all of this together, which are the prevailing social and cultural standards. This concept, prevailing social and cultural standards, are arguably the most powerful tool in your advocacy toolbox. This concept runs through everything we've discussed: who counts as an extended family, when placements are appropriate, and what constitutes good cause to deviate from placement preferences. The core principle is this: when decisions are being made about placements of an Indian child, those decisions must be evaluated through the lens of the tribe's standards, not the county's, not middle-class mainstream society norms, and not the social worker's personal judgment. So let's look at these specific statutory provisions. This provision is critical for cases where the tribe is not exercising its right to approve a home, meaning the family is having to go through the county's RFA process. Read the key language. In the case of an Indian child for whom the child's tribe is not exercising its right to approve a home, the county shall apply prevailing social and cultural standards of the Indian community to resource family approval for that child. Shall, not may, not should consider, shall. This is mandatory. RFA Written Directive 7.0 affirms this requirement and specifies that prevailing social and cultural standards apply during both the home environment assessment and the permanency assessment, which are two core components of the RFA. What this means in practice is that the county social worker cannot substitute their judgment for the tribe's about what is an appropriate home. If the tribe says multi-generational living is normal and healthy, the county can't flag it as overcrowding. If the tribe says that traditional practices are normal, the county can't call them a safety hazard without considering the cultural context. California ICWA has additional prevailing standards language that we'll look at on the next slide. Welfare and Institutions Code Section 361.31F is a broad provision. It applies to all placement decisions, not just the RFA process. The statute says that the prevailing social and cultural standards of the Indian community in which the parent or extended family members reside, or with which the parent or extended family members maintain social and cultural ties, or the prevailing social and cultural standards of the Indian child's tribe shall be applied in meeting the placement preferences. Please note the three possible sources of those standards: the community where the family lives, the community where they maintain ties, or the tribe's standards generally. This gives you multiple angles. So how do you prove what those standards are? The statute gives two methods: confirmation by the tribe itself. It could be a letter, a resolution, testimony from a tribal authority, or testimony or documented support from a qualified expert witness who is knowledgeable about the community's standards. So here's an important practice point. Always advocate for a qualified expert witness, or QEW, who is approved by the tribe. The qualified expert witness should be someone who actually knows the community's norms, not a generic ICWA expert or someone who knows about tribes generally. The federal statute has similar language, which we'll see on the next slide. 25 U.S.C. Section 1915D says that the standards to be applied in meeting the preference requirements of this section shall be the prevailing social and cultural standards of the Indian community in which the parent or extended family member reside, or with which the parent or extended family members maintain social and cultural ties. As you can see, this is similar to California, but Cal-ICWA adds the tribe's own standards as an additional source, not just the community where the family lives or maintains ties. Now we're going to talk about something that underlies all of this: why Native families may be reluctant to engage with these systems in getting approved as a placement. Next slide, please. So, we've spent the first part of this training on legal tools and arguments. Now we need to talk about the human context that, as the tribe's attorney, you need in order to represent your client competently. The families that want to welcome their relatives in their home may have deep, well-founded reasons to distrust government systems. This could include the child welfare system, the courts, and the approval processes we just discussed. This isn't paranoia. This isn't resistance to change. This is a rational response of communities that have experienced generations of government-sanctioned family separation. As the tribe's attorney, you need to understand this history, not just to be culturally competent, but also because it directly affects your advocacy. When a grandmother won't return a social worker's calls, when an uncle refuses the home inspection, when a family drops out of the RFA process, there's a context that you, the workers, and the court should understand. Judges and other attorneys may not understand why families are reluctant, and they may interpret it as disinterest or unfitness. It's your job to reframe that narrative. So let's look at the history that created this distrust. We're going to move quickly through several centuries of history, and I'm not going to sugarcoat it. This is painful material, but you need to know it to be an effective advocate. So there's 4 key periods that we're going to go through. Colonization, which is the beginning of forced family separation. Boarding schools, which has resulted in the systemic removal of children from families. Child welfare history, and the crisis that led to the Indian Child Welfare Act being passed in the first place. And ongoing disproportionality. It's not just history, it's still happening now. The impacts of each of these compounds through intergenerational trauma. A grandmother who was taken to boarding school carries that trauma. Her daughter, raised by a traumatized parent who might not have been taught how to parent because of the separation, carries that secondary trauma. And now her granddaughter is in the child welfare system. Understanding this isn't optional. It's essential to your work. So let's start at the beginning. In California specifically, there were Spanish missions, Mexican rule, and the Gold Rush era. And each wave brought devastation through forced labor, disease, genocide, and cultural destruction. Forced family separation didn't start with boarding schools or child welfare. It started at first contact. The government and settlers have been taking Native children from their families for over 250 years in California. The mission system forcibly separated families and imposed European family structures. During the Gold Rush era, the California legislature passed laws allowing the slavery of Native children. Settlers could legally take Native children from their families and force them into work. The history that shaped the landscape, place names, economies, demographics, but it also shaped deep, justified distrust of government authority that persists today. The next chapter is even more directly relevant to child welfare. The 1819 Civilization Fund Act led to federally funded boarding schools that operated from 1860 to around 1978. There were 357 schools across 30 states, and over 60,000 Native children were taken from their families. The philosophy is captured in an infamous quote from Richard Henry Pratt: "Kill the Indian in him and save the man." The explicit goal was cultural genocide, to destroy Native languages, Native religions, family structures, and identities. Children were punished for speaking their languages. They were given European names. They were forbidden from practicing their religions. And many were physically and sexually abused. The boarding school era didn't just traumatize the children who attended, it severed the transmission of parental knowledge, cultural practices, and family bonds across generations. Parents sometimes were never allowed to experience healthy parenting because they were raised in institution, and this led to them sometimes struggling to parent their own children. This is the intergenerational trauma cycle. This is an ancient history. Friends of mine were discussing a picture from boarding school on social media, and someone asked, "Which one's Grandpa?" Many of the grandparents and great-grandparents of the children in today's dependency cases are boarding school survivors. But even as the boarding schools were closing down, the child welfare system was stepping in. Next slide, please. So, the Association on American Indian Affairs published landmark research in the 1960s and 70s documenting the crisis of Native child removal. Key findings that led to the Indian Child Welfare Act being passed included the fact that 25 to 35% of all Native children were being removed from their families. 85% of those children were placed in non-Indian homes. Removals were often based on culturally biased standards. Poverty, different child rearing practices, and extended family caregiving were often treated as neglect. State agencies were applying middle-class norms to evaluate Native families. And this is exactly what we've been talking about: the failure to apply prevailing social and cultural standards. ICWA was Congress's response to this crisis. Next slide, please. So next we're going to look how the road to justice looked in California. We wanted to include this slide because it gives you a high-level view of how tribal families have sought justice in California. Please take some time to review it and deepen your understanding of this history. In the interest of time, I'm going to move on so we can talk a bit about how this trauma manifests today. When children are placed outside of their community, they lose contact with their relatives and their culture. This replicates the exact outcomes of the boarding schools: separation from family, loss of cultural identity, loss of language and tradition. Intergenerational trauma means that the effects of historical events, colonization, boarding schools, mass child removal, are passed down through families. It shows up as PTSD, depression, substance use, difficulty with attachment and parenting, and distrust of institution. But here's what's critical. This isn't just historical, it's ongoing. Native children today are removed at a disproportionate rates. Systemic bias still exists, and culturally appropriate services are still lacking in many jurisdictions. As attorneys, you need to be trauma-informed in two ways. First, understand that the families you're working with may be affected by this trauma. Be patient, be respectful, and build trust. Second, be prepared to educate the court about this context. A judge who understands why a grandmother is hesitant to cooperate with the county will view the situation very differently than one who does not. So let's think about how this trauma can affect placement with family. So I wanted to revisit this slide to use it as an example of how the trauma can be ongoing today. Relatives face real barriers in the RFA process. They face housing standards that might not account for cultural norms. The process by itself is, by its very nature, is intimidating and invasive. Criminal history can provide barriers, as we discussed earlier. Old and minor offenses can be brought to light. And for folks who get caught up in the federal justice system because they lived on federal land, they might have faced more serious charges than those who were adjudicated through the state system because of the very nature of the federal system. For families who have learned through generations of experience that the system can't be trusted, the RFA process feels like yet another government intrusion by people who don't understand them and who don't want to understand them. Your job as the tribe's attorney is to advocate for families, help them navigate the process, push back when the county applies inappropriate standards, and use the legal tools we've discussed, prevailing social and cultural standards, tribal definitions of family, placement preferences, to fight for placement with these families. While we must be trauma-informed, we should also be healing and resilience-focused. These communities have survived centuries of assault on their families, and that resilience is a strength. On a positive note, there's good news. For some time, child welfare policy federally and at the state level has been moving in the direction ICWA has always pointed. Next slide, please. This is important context. The broader child welfare system is increasingly recognizing what ICWA has said since 1978, that children do better with family. Federal and state policy is moving towards a kin-first model. So this is an opportunity for your advocacy. When you're arguing for ICWA placement preferences, you're not swimming against the current. You're aligned with the current direction of modern child welfare policy. So let's look at some specifics. Next slide, please. So California has a number of initiatives. They have non-relative extended family members, otherwise known as fictive kin. It can be an adult caregiver with established familiar or mentoring bonds. California has recognized these relationships since the late 1990s. It's a similar concept to tribal extended family, but for cases where ICWA doesn't apply. Extended family members are verified in ICWA by the tribe, but non-relative extended family member cases, the relationships are verified through private parties. AB 562, Justice Through Placing Children with Families Act, ensures that more foster youth are placed with relatives when it's safe to do so, asks counties to track and report kinship placement data, and the goal is a kin-first culture, language that echoes ICWA's placement preferences. Welfare Institutions Code, Section 361.4, talks about criminal exemptions for emergency placements and resource family approval. Previously, certain crimes automatically barred someone from becoming a foster parent. Now, relatives and non-relative extended family members can request an exemption. This is a complex law, but the key point is that a criminal history in some cases is no longer an automatic barrier for these relatives. Start identifying potential relative placements from day one. Even while reunification services are ongoing, you should be working with your client to identify every possible relative or extended family member who could be a placement. Get those individuals into the approval pipeline, whether it's tribally approved home or a resource family. Have them designated as a tribally specified home. If the tribe has placement preferences or extended family definitions, get them established and on the record early. Fourth, if a relative is identified who needs a criminal exemption, start that process immediately because it might take some time. So the earlier you act, the stronger your position if the case moves towards permanency. You want to be able to tell the court that we have identified a relative at the beginning of the case and they've been going through the approval process and they're ready. Next, we're going to discuss a California-specific permanency option that addresses one of the biggest barriers to adoption in Native families. Tribal Customary Adoption, or TCA, is one of California's most important innovations for Indian child welfare. It directly addresses a barrier that stops many Native families from pursuing adoption. So let's look at how TCA works. Tribal Customary Adoption under Welfare and Institutions Code, Section 366.24, allows adoption without the termination of parental rights. This is a key feature. With many Native families, asking a relative to legally sever a parent-child bond as a condition of adoption is asking the impossible. It goes against cultural values about family, it damages relationships within the extended family, and it often means that relatives who would otherwise be a wonderful permanent placement, simply won't pursue adoption. Tribal Customary Adoption solves this. The child gets permanency, a legally recognized parent-child relationship with the adoptive parent, but the birth parent's rights are not terminated. The tribal court, or tribal custom, defines the adoption, and it's recognized in the state court. Your role as the tribe's attorney is to know your client's tribal customary adoption process. How does your tribe, the tribe you represent, implement customary adoption? What's involved and who needs to be consulted? You should always consult with your client about whether tribal customary adoption is appropriate in each case. Not every case calls for tribal customary adoption, but when a relative is willing to adopt but unwilling to terminate parental rights, it could be the first option you consider. As the tribe's attorney, you should be prepared to implement tribal customary adoption. Know the procedural steps, have the forms ready, and be able to walk the court through the process. Always specifically address tribal customary adoption as directed by your client as the preferred permanency plan in your pleadings. Don't let the county default to traditional adoption or guardianship without considering tribal customary adoption if that is what your client wants you to do. Okay, this is our final practice tip. The case doesn't end at permanency. This is a point that often gets lost in the focus on court proceedings. Families need support after the child welfare case is closed. Relative caregivers, especially those who step up through kinship placements, take on enormous responsibility. They may be grandparents on fixed income. They may be aunts or uncles who have children of their own. They may be dealing with their own trauma while trying to heal a traumatized child. As the tribe's attorney, you should be advocating for services and supports that will sustain the placements long term. This could include financial assistance, including guardianship payments, adoption assistance, or non-needy caretaker supports through TANF. It could include the mental availability and accessibility of mental health services, trauma-informed therapy for both the child and the caregiver. It could also include educational support, tutoring, school advocacy, IEP support. It can include respite care, giving caregivers a break so they don't burn out. Argue for these services before the case closes. Once the court loses jurisdiction, it may be much harder to get these services in place. Work with tribal social services and other service providers to frame support as prevention. If you invest in supporting the placement, you prevent placement disruption and re-entry into the system. So key factors for this success include ensuring that there is consistent outreach. Don't wait for the families to ask for help. Someone should be checking in regularly. Work with social services at the tribe and hopefully with their partners at the county to normalize asking for help. In the context of historic trauma, families may see asking as help as a sign of weakness or an invitation for government scrutiny. Reframe it. Asking for help is a strength, and services are an entitlement, not a charity. This can benefit the existing relationship, the cultural continuity, family preservation, and community connection. Relative care can look different from non-relative permanent placements. It definitely has its benefits because the child is within their larger extended family, but that can also pose challenges. Have conversations with the family and work with tribal social services and county services who hopefully are their partners to talk about how the family is going to interact with the birth parent who might still be part of the community. This is a challenge, but it's also an opportunity for growth. Give them space to talk about how this could be done traditionally and recognize and support the role of grandmothers and elder women who are the backbone of many tribal families. Think about the role of male relatives. There's a growing movement to encourage men to step into caregiving roles. One example is the Native Dads Network, who provides programs specifically supporting Native fathers and male relatives in caregiving. So to recap today's practice tips, first, know your client's definition of extended family. Second, know their placement preferences and advocate for them. Third, anticipate good cause arguments that may be made to deviate from those placement preferences. And fourth, ensure that the placements are considered in accordance with the tribe's prevailing social and cultural standards. Fifth, know how families are approved as placements. Know the resource family approval process. Know how your client approves homes, if they do. And also understand how they specify homes as their desired placement. Sixth, advocates for families who don't trust state and county systems. Seventh, know how your client implements tribal customary adoption. And last and finally, be prepared to argue for services and supports for the family after the child welfare case is closed. Now, please take about 10 minutes to complete the post-test in Google Classroom and compare your answers with the pre-test. We also invite you again to look at the progressive case study materials that are in Google Classroom to help you deepen your knowledge and think about how you would implement these things in practice. Here's our contact information. If you have questions or comments on this presentation, we'd be happy to speak with you about them. So there's Catherine Ratana. She's our tribal law specialist, and she's at CATHERINE@tlpi.org. And I'm Suzanne Garcia. I'm also a tribal legal specialist with the Tribal Law and Policy Institute, and I'm at SUZANNE@tlpi.org. Thank you for your engagement and your commitment to tribal children and families. The work you do matters enormously.